All right, welcome everyone. I am delighted to welcome you back to my COVID-19 conversation series. I'm Professor Tyler at UC Berkeley School of Law, and I have the great honor and privilege of welcoming two very distinguished guests, Bob Bauer and Jack Goldsmith, to talk with us today about their new book, and I'm going to hold it up because it's got a great cover, After Trump, Reconstructing the Presidency. First, I would like to introduce our distinguished guests, and then let's talk about the book. So first, Bob Bauer. He is a professor of practice and distinguished scholar in residence at New York University School of Law, and he is the co-director of NYU's Legislative and Regulatory Process Clinic. He has had a long and distinguished career in which, among other things, he served as White House counsel to President Obama, co-chair of the Presidential Commission on Election Administration, general counsel to President Obama's campaign, and counsel to the Democratic leader during the impeachment trial of President Clinton. A graduate of the University of Virginia School of Law, Bauer is a prolific author, and prominent voice on the executive power. Jack Goldsmith is co-founder of the Lawfare blog and the Henry L. Shattuck Professor of Law at Harvard Law School. He served in the second Bush administration as special counsel to the general counsel to the Department of Defense and as assistant attorney general in the Office of Legal Counsel. Also a prolific author, Goldsmith has published a number of important books, including The Terror Presidency, written about his time in OLC and discussing post 9/11 national security challenges, and most recently, a book I highly recommend, In Hoffa's Shadow, a book about his stepfather's relationship with Jimmy Hoffa and the government's treatment of Hoffa. I would be remiss if I did not also mention that Jack is a co-editor of Hart and Wexler's The Federal Courts and the Federal System, where it is a great privilege for me to work alongside him. A graduate of Yale Law School, Goldsmith served in several postgraduate clerkships, including one with Justice Anthony Kennedy at the Supreme Court. So thank you both so much for joining me today and being here.
Thank you very much.
Thank you for having him.
I want to talk about this book. It is so important. It's really an exceptional and extremely thorough work that could not be more timely. Indeed, as I was reading the book, I was thinking just in the weeks since it's published, there's material that you probably would have included if you'd had the opportunity. And I want to note that this is the very first book published by Lawfare, and it sets quite a high bar in that regard for those that will follow. What I wanted to ask you both at the outset was why you wrote this book. What drove you to write this book? And also as part of that, what drove you to write this book together, given that you'd served in different administrations? Bob, might you say a word about that? And then Jack?
Certainly. We did not know each other terribly well. We had had the occasion to meet. I was teaching a course on presidential power with another faculty member at NYU, and we invited Jack to that class, largely to debate the comparative merits of the Bush and Obama administration counterterrorism policies. And then subsequently, we had a closed-door session on executive power issues at NYU, and I met Jack there. And so we got to know each other, began discussing these issues. This book originally arose out of a project we considered writing a book about the White House counsel's office, the office of the White House counsel. But once we began to discuss that, we decided there were a host of issues in the conduct of the presidency, the norms and the rules that govern presidential conduct, the legal advisory function that supports the president. And we decided to significantly broaden the scope of the book, and it went from there.
Yeah, and I'll just add, we didn't know at the outset. We started one morning talking about the White House counsel, and by the end of the day, after a long day of meetings, we were going to write this book. We didn't know we had a general sense of what the topics were. We didn't really know what we were going to recommend. We didn't know how much, if we would agree. But we thought that we felt very strongly, we felt that day in talking about all the issues that Trump had implicated, many of which started in his administration, but some of which predated his administration. It seemed apparent to us, and this was 18 months ago, that there was going to be a huge conversation after Trump left the scene about the state of the presidency, primarily because of what he had exposed in terms of weaknesses and gaps in the norms and the law, and how the political context had changed. And so we thought that there's going to be, and we do believe there's going to be, after Trump leaves the scene, there's going to be a 70s style, the conversation about 1970s style comprehensive reform of the presidency. So we set out to do that. We believed that we could bring value added to the project, both because we had significant executive branch experience, one in the Justice Department, one in the White House, two different administrations. We also hoped that there would be value added by people with different perspectives coming together and seeing how much consensus we could reach about these issues. And we think we were successful in doing that.
Well, you clearly agreed on quite a lot, and time, in the time we have, there's no way we can go through all the reforms you suggest, though I do want to highlight a number of them. But it is quite remarkable that you did agree on so much and you came together to suggest so many reforms. One of the things that struck me at the outset of the book is that you both, and again, coming from your different experiences, you come together and you agree and you lay down as a marker that you should not be misunderstood here. You believe in the importance, both of you, of a strong presidency. And it's not that you would react to what we've seen in these last few years by scaling back necessarily the powers of the presidency, but instead providing for the reforms and promoting the reforms that you suggest. So I wonder if you might say a word about why you both still very much defend this idea of a strong presidency.
Sure, I'll take that one. So it's not like we don't. Our reforms there are dozens of them, and they would, in important places, significantly constrain the presidency. It's not like we're not in favor of robust reform, but there's a foundational question at the beginning of what is the nature of this office in our constitutional democracy. And we are of the view, and basically people don't realize this was Arthur Schlesinger Jr.'s view, the author of the imperial presidency in the 70s. This was exactly his view, is that in the modern world, given the complexity of society, given the complexity of running the country, given the dangers and complexity of foreign affairs, that a powerful presidency is absolutely vital for making the government work, and frankly, for making separation of powers work when it's working the right way. And so we don't call for fundamental reform to Article 2, and our aim is not to significantly reduce the basic powers of the presidency. Our aim is, because we think that we're going to have a powerful presidency, our aim is to bring that presidency more under law, make it more accountable, to fix the numerous norms that proved to work pretty well for 45 years, but in this administration just kind of collapsed in many places. So, we kind of make clear at the outset, this is not a radical constitution changing project. The reforms are in many places very aggressive and some places maybe unusual, but we're basically committed to a strong presidency.
Yeah, so, and as you say, that influences a lot of what you suggest. There aren't proposals in here, as you say, to rewrite Article 2 and try and affect the powers there. But as you also say, so much of what you discuss here has been governed by norms as opposed to binding statutes. And that's something I want to return to and talk about after we cover a little ground in the interim. You cover a lot of ground in the book. There are a wealth of reforms suggested here, and you even have proposed language to make it easy for legislators to pick up and act on your proposals, which I think is just great. There's no way we can talk about all the reforms that you suggest, but there are quite a few that I think are incredibly timely and important. And I do want to talk about several of them and then maybe have a broader conversation about how these reforms should, how they're situated in these larger discussions that you've made mention of. In the first set of reforms that you start with, and I would gather it probably wasn't an accident that you started with them because they could not be more timely. You talk about controlling against foreign influence in American elections. And I wonder if you might share with the audience what more you think could be done on this score.
So we try in every single chapter. It's important because so much of the Trump administration has been characterized by a fight over that particular issue and a controversy over that issue. We try in every chapter to situate the Trump experience within the broader history of the presidency with respect to a particular issue. So even in the foreign influence chapter, we open, as we do with every chapter, with a background historical discussion. And we note that this is not the first time this sort of controversy erupted, although in one notable instance, it erupted to public attention sometime after it took place. And that was Richard Nixon's attempt, successful apparently, to negotiate through political channels in 1968 with the South Vietnamese government to dissuade them from engaging constructively with the Johnson administration to reach a peace agreement in Vietnam. Nixon's concern being, of course, that a 11th hour peace agreement would benefit Hubert Humphrey's presidential candidacy. And after that, we proceed to discuss, again, as every chapter does, moves from the historical discussion to the Trump discussion, and we proceed to discuss the set of issues that have been presented by the Trump presidency. And we express the view that these are not questions that are likely to disappear once Trump has left office. So very briefly, our reforms fall into three parts. The least significant, the least controversial, I suppose, would be an amendment to the campaign finance laws that has been proposed and that we discuss, that values certain information that travels from a willing foreign government to a political campaign that has use for the political campaign, and that Bob Mueller in his investigation found difficult to fit into the campaign finance laws definition of a contribution. And there's a way to very simply fix that so that the transfer of value like that from a foreign government for election influencing purposes to an American presidential candidate could be characterized as a contribution. And if it was a contribution, it would be illegal because foreign nationals cannot, under American law, make contributions to federal candidates. More consequentially, I think, or more broadly gauged, are two other reforms, one of which simply, and we discussed it at length, would impose a reporting requirement on presidential campaigns that are contacted by a foreign power for an election influencing purpose. We refer to the sort of arrangement we're addressing as a political strategic alliance. The foreign government, in effect, shows up to say, we would like you to be elected president, and let's have a conversation about ways in which we can be helpful to you. And the American presidential campaign accepts the offer. Any such contact from a foreign government we think ought to be reportable, and we describe, as we try in all of our reform discussions, to be fairly specific about how that reform would be structured. And our departure point is a proposal that was introduced in the Senate by the ranking Democrat on the Senate Intelligence Committee, Mark Warner. The third reform I'll just mention briefly, but it's the one which we think breaks some new ground, and is intended to attack those cases where the presidential campaign and the foreign national, the foreign power, have entered into a strategic alliance, but it isn't clear how the campaign finance laws exactly apply. And an example would be, incidentally, the Nixon case, where there was clearly a strategic political alliance, but it's not as if the South Vietnamese provided Nixon with opposition research on Hubert Humphrey or anything that you could put into the classic category of a contribution. And yet it was without a doubt a political strategic alliance. And the similar experience that we discuss is the one that's now known as the Trump Tower meeting in June 2016 between the senior management of the Trump campaign on the one hand and emissaries from Moscow who came to find out whether they could market some opposition research on Hillary Clinton, having said, we would like to be helpful to you because our government intends to support Donald Trump's election to the presidency. And so we propose the amendment of an existing statute that doesn't apply in this case, applies to essentially lobbying relationships, to apply to a political relationship like this and to prohibit it if entered into by a public official, by a campaign for this prohibited purpose.
So, you know, what I found is so interesting about many of your proposals is some have even the suggestion that there should be criminal liability in some cases. And it's interesting how you've chosen in certain contexts to provide for that and in others, not necessarily. One of the areas, picking up on what we've learned in the last 4 years, but of course it's not a completely unique problem, as you say, with respect to Donald Trump, but a problem that Donald Trump's presidency has really laid bare is the potential for financial conflicts of interest. And in that chapter, in that set of reforms, you actually do suggest maybe there should be a criminal portion to some of the reforms put in place. And I'm wondering if you could talk a little bit about those proposed reforms, and also if one of you can speak to this, and also why in that context, for example, you think maybe having a criminal element to liability might be especially important.
So I can take a first crack at that, and Jack can enter in as he sees fit to supplement or correct. Our view on that is that we have seen with Trump that a president can undertake to run the government concurrent with the ongoing management of a business, and that we do not currently have in place, beyond norms that Trump himself has shattered. We don't have controls on that can be enforced against a president. And so, among other things, we propose a complete separation of a president from the president's business interests. We do not support, and this is probably a controversial feature of our reform, we do not support the organization of blind trusts. Our view is that the public ought to have complete visibility into the finances of the president. By the way, this relates, of course, furthermore to our extensive discussion of how you would structure a requirement that the president disclose his tax returns.
Mm-hmm.
But in all of those cases, our view is that that visibility has to be available. And there's a reason which we discussed why a blind trust ultimately defeats it and also promotes all sorts of potential avenues of circumvention. And in connection with the president separating himself or herself from the business interests, and then imposing on the businesses themselves in which a president has an interest, a public reporting responsibility, we do believe that the president has to make certain certifications that he or she has complied with that separation that we would impose by law. And that would be subject to criminal penalties. And it's simply important, it seems to me, to underscore, first of all, in any affirmation like that to the government, that a knowing misrepresentation is sanctionable under the criminal laws, but it also certainly brings home the importance of it and helps to shore up the norm that we're trying to revive that has collapsed during the administration. As in every other chapter, and I'll conclude here real quickly, as in every other chapter, there are other ways in which we try to attack the problem. I've talked about the business reporting requirement, the tax disclosure requirement. But in addition to that, we also think that presidents should not be encouraged to believe that they have any other professional, if you will, interests they're supposed to manage while they're president or permitted to manage. President Trump has made an issue. In fact, in his campaign has said, after all, he turned down his federal salary and was prepared to donate it for the use of the federal government. No one can force a president to use a federal salary, but we can discourage a president from declining a federal salary by, for example, denying him or her the opportunity to donate it to the federal government or to take a charitable deduction on it and then use that salary to make a political point by providing it to some charity that's politically or publicly beneficial. Our view is the president is paid by the taxpayer to be president and only president, and that is the one job that he or she should have. And it is having multiple interests that gives rise to potential and serious conflicts.
I think several things struck me about those chapters. One that struck me was that you're working both towards improving transparency, but also to attacking potential conflicts of interest. And the reforms you suggest march in the same direction toward those goals. I do wonder a little bit about, and this could be a good or a bad thing, whether such reforms if put in place might discourage certain people from seeking public office. And it would be interesting to see if they are adopted, whether that might actually be the case. That, again, might be a good or a bad thing. Of course, it depends on the kind of people we're trying to attract to serve in public office. You also have a chapter on the press and on social media, which, again, is such a timely issue when you think about Twitter and the president's use of Twitter, but also how much the press is invited in to cover the presidency. And I wondered, given just how timely those issues are, if one of you might say a few words about what you're proposing on that score.
So just so you know, Amanda, Bob's going to answer that question too, because we've kind of divided these up between
Okay.
ourselves, and you're marching through in an
And-
order that
and
gets
I'm going
him
to
up
turn to
first,
you
but
next.
I do have stuff to say later on. Don't worry.
Okay.
So on the press question, we discussed in the historical background, obviously Trump is not the first president to have a fraught relationship with the press, nor the president or president who has been moved to attack the press, and in some cases to retaliate against the press for what the president viewed as unfavorable coverage. However, as in so many other areas, Trump has taken matters to an extreme in the cancellation of press briefings, in the attempt to run certain reporters who he does not like, whose questions he disapproves of, out of the White House press briefing room, to revoke their press passes. We recognize that there are limits to what you can do to force the president to engage with the press in the White House space. And there's case law on that. There's clearly limits. If a president chose, for example, to give interviews only to publications that were favorable to the president's political ideology or program, a president could do that. Might pay a political price, but the president's not required to be even-handed in his or her exposure to the press. However, there are regulations that the executive branch has promulgated that govern, for example, the issuance of revocation and revocation of press passes. Our belief is that the president who takes office after Trump ought to revise those regulations and use them as an occasion to establish genuinely acceptable standards for the issuance and revocation of press passes, so that there isn't in that activity sort of the unconstrained impulse to simply utilize that press pass authority to reward friends and punish enemies. We also believe that the Presidential Records Act ought to be amended to make it very clear that, contrary to President Trump's position, his Twitter account, which is a means of controlling the conversation without press involvement, and he has said so publicly and in court filings, is in fact a government channel of communication, and he is not able to use it to shut opposing points of view, say, out of the comments section. This seems like a small thing, yet at the same time, again, we're trying to emphasize and shore up norms. So last but not least, we also think, and this was true during the Nixon administration, that Congress needs to pay a little more attention to these issues of press access to the president. There were, in the 1970s, in connection with Nixon's famous war on the press, an attempt on the part of the Congress to conduct oversight. And in particular, and this is probably the key reform that relates to congressional oversight, we would give the Inspector General statutory authority to review on a very structured basis. And there are a lot of qualifications we build into this program that I won't go into here. But the Inspector General of departments ought to have the capacity to entertain allegations that the president initiated official action within the government to attempt to harass or retaliate against the press, and then make those findings public so that Congress can follow up on them. There are, again, some complicated pieces of that we discuss in the book, but those are the component parts of the reform, and the last one is probably the one that would have the most bite.
Right. So, I mean, so many interesting proposals there to strike at so many norms violations in this administration and set a different tone going forward. If I can shift gears and try to bring Jack into this as the resident expert on the Department of Justice. As I was going back over thinking about a few months ago, interviewing Ben Wittes and Susan Hennessy about their book on making the presidency, I recall that they say in there that Trump's corruption of the justice system is among his gravest breaches. And I wanted to ask generally whether you agree with that, and then more specifically, how you would propose we reform some of the norms that he's violated in this regard. And in particular, there are a host of proposals in the book related to the pardon power and also the Department of Justice.
Yep.
What might you say about those?
So we agree with Ben and Susan that among his, I mean, there's a long list of extreme norm violations and inappropriate actions by the president. But if you had to put it into the category of the most concerning things, it's the array of things he did with vis-a-vis the Justice Department and law enforcement and the like. And one piece of evidence for how important we take this is we devote basically a whole part of the book, part 2, to White House Justice Department relations. Now, the problem is that there are many things that come under that category. I'll talk about a few of them if you can follow up with whichever pieces you want. But in general, the problem is, just to state what the difficulty is, the difficulty here is that, as you know, Article 2 of the Constitution vests the executive power in the president and says that the president has a duty to take care to faithfully execute the law. And those two powers have been interpreted to give him broad supervisory authority over law enforcement in the executive branch, including over prosecutorial decisions. So that is a very, very fraught power in the hands of a corrupt president who is barking out orders daily to use the law enforcement power to hurt his enemies, to help his friends, to protect himself, and the like. And so that's one of the things he's done. I think the most corrosive of the things he's done, basically, and he was doing this morning, apparently. I just barely read about it, but it's been something he's been doing for almost 4 years now. Basically saying that it's calling on the prejudging cases about who's guilty of what and who should be prosecuted and urging his Justice Department to prosecute people. These are all enormous norm breaches of the norms that were set down in the 1970s. Basically, he hasn't violated the law in doing that, but he's really destroyed the appearance and the reality of the fairness of law enforcement for any of these cases. So what do we do about a president who does these things? The first thing I'll just mention 2 qualifications before I get to reforms. One point is that we should keep in mind that norms have not completely collapsed. That despite this most norm defiant of presidents, a lot that in many contexts he wasn't able to achieve his goals, even with his political appointees in the White House and the Justice Department. The best example of this is Volume 2 of the Mueller report, where under the context of 10 possible examples of obstruction of justice, Mueller lays out time after time when Trump tried to intervene in the ongoing Mueller investigation, to fire Mueller, to get him to drop prosecutions, to shape the prosecution in a way that seemed to serve the president. The extraordinary thing about Volume 2 of the Mueller report is he failed. I mean, he had the power to achieve that result, but he couldn't get it done. And he couldn't get it done because even his political appointees in the White House and the Justice Department were basically insubordinate. And they did that, we don't know, but it was a combination of these norms that still work and perhaps a whiff of the obstruction of justice statute that they were worried about. So the first point is that norms have not completely collapsed, although they were going in a bad direction, and Attorney General Bauer, maybe we can talk about this later, has contributed to the problem in the last year. Second thing to keep in mind, and then I'll get to the reforms, is, and this is a hard point for some people to accept, but you can't completely remove politics from law enforcement. There's a reason, there's an affirmative justification for the president being in charge of law enforcement, and that is that it's been long accepted in this country that the president, as the elected chief of the executive branch, part of what he's elected to do is to set law enforcement priorities. And where to draw the line between the president's ability to do that and to direct prosecutions that he thinks serves the national interest, there's just a broad scope in which that's perfectly acceptable, even in contexts where it's controversial. So that's another, basic problem you have to contend to. So what does one do about what Trump has done? There are a whole array of problems. And I'll mention 2 or 3 and you can follow up however you want. So the first set of things we talk about is the special counsel's office. We have a number of reforms. This was a number of reforms to the special counsel regulations. This was, of course, the regulations pursuant to which Bob Mueller conducted the investigation of into the alleged or possible contacts between the 2016 campaign and Russia, and the follow-on investigations into the president's possible obstruction of justice. So these regulations, just to give historical context, these regulations were put in place in 1999 in response to what was then widely considered the failed experiment with the independent counsel statute that was part of the 70s reforms. And there was a consensus that control had to be given to the Attorney General over legal issues, but there should be the special counsel under the purview of the Attorney General, not subject to judicial appointment like the earlier statute, no reporting requirement to Congress. This should really be under the control of the Attorney General. And as we talk about in detail, I won't get into them. This is the first experience the country's had 20 years later, really, with those regulations. And we learned a lot about how they operate. And to make a long story short, we basically proposed 3 fundamental reforms. It's a lot more complicated than this. The main and most important reform, we think, is that the special counsel, and remember, why is the special counsel important to answering this question about independence? Because the special counsel gets appointed when there's a question about high-level wrongdoing in the executive branch. So this goes to the core of conflicts of interest in law enforcement in the executive branch, which is why this is so important. The idea is you appoint a quasi-independent entity to look into alleged criminal wrongdoing, as Bob Mueller did. The most important thing we propose, and probably the most controversial, is that the special counsel be given what it just be recognized and built into the regulations that the special counsel has what we call an accountability function. That it's not just a prosecutorial function, that part of the special counsel's job in the course of doing a criminal investigation is to collect facts about what happened. Bob Mueller did a 400-page report. It was very important to the country in that context to know what happened. And so we take special care to give the special counsel special protections to ensure that the special counsel can continue in his or her job, get the fact-finding done, and get the facts out in the public. There's a question under the 1999 regulations. Bill Barr could have not disclosed that report if he didn't want to under the regulations. It was political pressure. He committed to it at his confirmation hearings, but we don't think that should be left to the discretion of the Attorney General. We think that that fact-finding function and the publication of that should be sacrosanct, and that is probably the main controversial reform. Another controversial reform is, it's not really a reform, it's just clarifying, is that we actually think that it has to be clarified that the Attorney General remains in charge of legal interpretation. There was a lot of disagreement between Mueller and Barr on legal issues, and it's not at all clear that Mueller really followed the regulations and complied in terms of deferring to the Attorney General's legal judgments. This is a complicated issue, but we think for accountability reasons and basically for the reasons that the 1999 regulations were set up, it's important that the Attorney General be in charge with a few caveats to protect the accountability function of the legal interpretation. But finally, since that raises all sorts of problems on its own, we build in a series of transparency requirements to ensure that if the Attorney General is acting in what seems like a self-interested fashion or a self-serving fashion to under-enforce the law, that at the minimum, for example, disagreeing with the special counsel on a legal issue, at a minimum, that has to be disclosed to Congress, depending on whether it's classified or not. So that is a check on the Attorney General. That's a long-winded way of saying basically that we think that the accountability function is vital and needs to be protected in the special counsel. I've gone on a bit. I can talk about some of the other reforms. I'm not sure what on independence and DOJ, but that's one of our main ones.
Yeah, well, I thought it's really important because we now have the lessons of several of these investigations, and including the Mueller investigation in particular, and you propose reforms that so wisely engage with some of the failings that we've seen play out. You also talk, and we can come back to this maybe later, you talk about the pardon power. I have a bunch of questions I would ask about some of your proposals there. It's something I've written a little bit about, but in the interest of time and maybe a time permitting, students, hopefully we'll have time for questions. I always aspire to do that. We'll see, but if you do have questions, put them in the Q&A format at the bottom of your screen. I do want to at least touch on one other set of reforms that are in the book, and they go to the balance of powers between Congress and the president with respect to emergencies. Among other things, you propose that Congress re-engage, for example, with the existing authorizations of use of military force, re-engage with the War Powers Resolution, some of that 1970s legislation you refer to at the outset that came during that period of extensive reform. Might you say a little bit about those reforms, why you think they're necessary? Indeed, the book goes so far as to talk about reforms with respect to who gets to make decisions about nuclear arms. So there are some fairly substantial reforms being suggested here. Why do we need them?
Yes. So our suggestions about war powers and about reforming the president's control over nuclear launches, basically, is almost certainly the heaviest lift in the book, because there's potential for a lot of the reforms in the book can be unilaterally implemented by the executive branch, and on a lot of proposals in the book, there's a pretty clear path to seeing how you might get bipartisan consensus on things like tax disclosure and conflict of interest. But on war powers, this is a fundamental problem of politics and law between the executive branch and the Congress. So we recognize this as the heaviest of lifts, and yet we think that it's very important, and in answer to your question, I'll explain why. So there are two baskets within the war powers discussion, as you said. One is, the creeping, growing executive power to engage in unilateral war, either under Article 2 or under the ever-expanding authorization to use military force, the 2001 statute that's been the font of basically the so-called war on terrorism for almost 20 years now. And a set of proposals about nuclear weapons. So we started off the chapter just talking about nuclear weapons, because when we first wrote a first draft, because Trump, as you recall, in his when he was kind of seemingly irresponsibly and jokingly over Twitter, these kind of crazy threats to use nukes against North Korea, the question was put on the table in a way it hasn't been put on the table since the 1970s. Do we want the president to basically have carte blanche to fire nuclear weapons? And that is the current regime in the United States right now. It's not well laid out. A lot of this is classified, but the current regime in the United States right now is basically the president gets to decide what he wants. And there's been a lot of discussion about, well, would people carry out his orders and blah, blah, blah. But basically there's no effective legal constraint on the president now. Now, this is a very delicate and complicated area because we have a nuclear deterrence policy, and it's important. Being able to launch these weapons or credibly threaten to launch these weapons is very important for deterrence. I won't get into the details, but basically we're led to what we basically propose is that the president of the United States need not have any authorities to launch nuclear weapons that goes beyond the United States, the common core of the United States longtime nuclear deterrence policy. So we basically the aim there is to put some of the crazy hypotheticals that concern people under the Trump administration and that we don't think any president should have the power to do, to take those off the table. After we wrote that, some people said, well, what about war powers generally in early drafts? And the truth is that on war powers generally, the AUMF and unilateral war, Trump has done some controversial things. The Soleimani strike, he's twice bombed Syria in humanitarian intervention. And he's expanded the AUMF a little bit. He's contracted in other places, but this has not been a kind of signature Trump abuse. It's kind of more of the same along the lines of what the last two administrations have done, I think it's fair to say. But not every one of our reforms is just a reform about things Donald Trump did. And in fact, almost all of them have prehistories before Trump. The problems were on the horizon in various ways. This is one that Bob and I both think, and this is something of a surprise, because when I was in the government and the executive branch, I wrote opinions in support of these things, opinions to take a robust view of Article 2. Bob was involved in the Libya matter in President Obama's use of force in Libya. And we actually take a pretty strong stance in favor of reform. And I'll just, time is short, so I'll just say some of these I think are kind of standard and on the table. Some of them are harder. It seems pretty clear that the Congress needs to re-engage on the 2001 AUMF. We think that Congress should reenact that statute, should make clear exactly who the enemies are. The enemies as described in the 2001 AUMF really don't match up to who the enemy in the conflict is today. We think there should be a process, a joint congressional presidential process, when the president, basically right now, the president adds to the list as the president wants based on this very vague co-belligerency test. We think there should be notice to Congress, and Congress should have a role there to at least push back if it wants. Perhaps the most important reform there, again, this has been discussed, is a sunset statute, 2 to 3 years. We just think that there should be a mechanism to force Congress to exercise its constitutional responsibilities to re-engage. We have some other proposals about the war powers generally. We propose to make humanitarian intervention not something the president can do without congressional authorization. But those are the guts of the reforms.
So your discussion of all of that leads to a broader question that I wanted to ask of both of you about the book. you're proposing all of these reforms. So there's several broader questions I want to ask. You're proposing all of these reforms. They're speaking to a lot of problems that we've seen in these last 4 years. And as you say, some of them predate. The war powers problems definitely predate Donald Trump's presidency. But a lot of what you've been saying throughout turns on Congress getting on board and providing for these reforms, adopting these reforms in many cases in statutes. And that begs a question whether that's a realistic hope, whether Congress will in fact do this, or whether maybe we need somebody to write the equivalent of your book with respect to Congress, Reconstructing Congress, because this is a Congress that is not especially functional, which is probably the nicest thing I could say. How important is restructuring and reconstituting of an effective Congress for you to achieve what you propose in this book?
Bob, you want me to take that?
Sure.
You want to take it? You want to take it?
No, go ahead, please.
So several things, Amanda. That's a great question. No, we say up front that a couple of things in response to your question. First, this is a 400-page book, and it's about the presidency, and we basically take the other institutions as we find them. We accept Congress with all of its pathologies. We accept judicial doctrine. We accept Article 2 doctrine, and we're working within extant law and the extant political framework. And as you say, the extant political framework is that Congress has basically dropped off the radar screen as a functioning institution. And we acknowledge that this is a large problem for the parts of our reform that require congressional input. Now, the first point is half of them don't require congressional input. So there's a lot that can be accomplished unilaterally by the president. With regard to congressional reform, so there are a lot of statutory proposals in the book. Some of them we think are not going to be heavy lifts. I mean, assuming that if Vice President Biden wins the election, this book is not tied to that happening. It's called After Trump, whether it's 2021 or 2025. But to take a plausible scenario, if Biden wins the presidency and the Democrats win the Senate, many of these reforms, there's already proposals, some of them in consultation with us, that Congress has proposed that across an array of these issues that Congress should be interested in. And there's no reason at all to think that the Biden administration will oppose reforms if it wins the election, that it will oppose reforms on conflict of interest, on some form of foreign interference, on tax disclosure. A lot of these issues, even the pardon power in some of the extreme cases, a lot of these issues shouldn't implicate separation of powers concerns. And so they're actually plausible candidates for reform. We don't know, and we don't know when Congress will engage in reform. We think there's a decent chance it'll happen next year. Most of our reforms require one-time input by Congress, kind of like what happened in the 70s, a one-time revival where Congress exercises its responsibilities, re-engages, and then puts mechanisms in place that hopefully can work better. And by the way, a lot of those reforms in the 70s did extremely well for a very long time. Having said all that, we accept in the book that Congress is a dysfunctional institution and that this might not happen, especially for some of the harder reforms like war powers and vacancies and the like. I actually think another reason we focus on the presidency is not just because it's our expertise, but we think that that's actually the chance. As hard as this project is, it's a lot easier than fixing Congress. It's just a lot easier than fixing Congress, which requires fixing Congress internally, fixing the electoral system. That's just another, as you say, another book. So we didn't propose, Bob probably has something to add to this, but we didn't propose reforms to Congress. This is a book about the presidency.
No, I think that's right. I mean, we make proposals for what Congress can do, where we think it can make a contribution. But as far as addressing the concern that you have, which is that it's dysfunctional, how can you address more broadly its dysfunctionality? It's for a different project.
Yeah, no, and I think there's another project about reconstructing the party system. So we've got a whole host of scholarship to be written.
Yeah.
Yes.
But I think all of those things, for what it's worth, are harder than these reforms, including getting Congress to weigh in on a one-time basis on a lot of these. I think that's not a crazy scenario next year as a possibility.
Yeah, I don't disagree. one of the things that really strikes me about your book and the project, it stems from something you just said, and it's something I was thinking about as I was reading it. You mentioned that a lot of the reforms that are proposed are reforms that the president himself or herself could institute. And then, of course, if those norms are adopted into regulations and binding practices, it would be for the next president to lift those, which would be more dangerous, I think, probably to the outside viewer than simply violating an unwritten norm. But that's relying on the president himself or herself to take your proposal seriously, to confront the problems, the very serious problems you highlight seriously. And it's also the case, and this is something else that struck me in reading your book, that you can only do so much with written statutes and regulations, that there still will be a huge area in which norms are going to matter, and taking norms seriously are going to matter. This is something I've written a little bit about in looking at World War II and the detention of prisoners in the UK and the US. But the character of the individual in the office, I think, inescapably matters. And I wonder, even with all of the reforms that you suggest, what you might say about how important that will remain as something to think about when we talk about the presidency.
Well, I can open up the round on this one by saying, of course, it's usually important, particularly if a president were determined, and we talk a little bit about, and I think Jack mentioned earlier, certainly we mentioned in the book, somebody who might have skills that Donald Trump lacks. I mean, he tends to use sledgehammers, not to say that there's anything particularly subtle about some of what he tries to accomplish, but you imagine a president who is skilled at doing some of the things that we think are really dangerous, say, to depoliticize law enforcement, and goes about much more quickly than Donald Trump has done, although Donald Trump has done it, and begins to clear out of the government the people that he believes will not comply with these norm-shattering requirements and requests and demands and the like. And that is a significant risk. If the president's character is problematic, and on top of that, the president begins to thin the government out of people who are prepared to resist the president's demands, then you have the making of a really extremely dangerous situation. So character matters both in the Oval Office, and character matters across the board, to the extent that a president begins to try to mold an administration, shape an administration that frankly reflects his or her character. And once the entire administration is, if you will, infected by that characterological problem, then you don't have some of what we've seen in the first term of Donald Trump, resistance to the demands to fire Mueller, resistance to the calls to prosecute political enemies. You find more compliance because the people that have been selected to do it are people who share the president's objectives and frankly share the same weakness of character. So it's usually important, as is, quite frankly, public intolerance for that behavior. Jack, you may want to.
Yeah, and I'll just add the flip side to that. The flip side to that is affirmatively, I'll answer your question, but I want to underscore something you said. There's only so much that a reform program can do in terms of changing the structure of the executive branch, moving the boxes around, trying to buck up norms, putting other constraints on. We acknowledge, readily throughout the book that there's certain problems that can't be reached. There's nothing you can do to stop a future President Trump from blabbing the way he does, and it's enormously destructive, even if he doesn't, because of the way he talks. It's enormously destructive, even if he's not able to follow through. And there's a whole host of things that one can't get at through legal reform, which is another way of saying that ultimately, and we say this in the book, it's up to the American people to pick a president with a certain character. And I think that the single most important factor in the success of putting the presidency back on a more legitimate footing is the character and commitment and actions of the president with regard to all of these issues, and the Attorney General, I think, is also hugely important. And if I frankly think that's as important as anything else. That's not something that we can talk about as a reform, that's up to the American people to decide, and the American people can put whatever kind of president they choose to put in. The premise of our book is everything would be a lot better with a presidency with checks and balances stitched into his or her soul, as something like that. Schlesinger said something like that. But that makes everything better, but we're assuming the worst. This is a book written on the assumption that we may have a brief period where we can achieve reforms, but that populist, demagogic, norm-breaking presidents, left or right, may be part of our future. And so a lot of our reforms are designed to address those worst-case scenarios.
Yeah, and this is also important. I keep thinking back to Churchill shutting down their domestic internment program during World War II. He wrote his Home Secretary, and he said, you know, against the backdrop of the program being wildly popular, shut it down. And he said, people who are not prepared to do unpopular things and defy clamor are not fit to be ministers in times of stress. So this is obviously a really important component to any person who holds high office, and not just, as you say, the presidency. I want to make sure I get at least one more question in. I see we've got some student questions coming in. Students, if you want to add any, please chime those in. But I wanted to ask you this. Patrick Henry at the founding warned, as was his fear, that the president could become a king. And a lot of people are really worried about this, particularly if we see Trump reelected. And I wonder if you're comfortable speaking to how worried we should be if he's reelected, whether we're going to have too much work to do to regain the ground that has been lost, that you've cataloged in your book.
Do you want me to take that, Bob, and you finish, or do you want to go first?
I'll take a crack at it. I will concede. So I'm on leave from NYU this semester. I will say right at the top, as a transparency matter, I'm currently on the Biden campaign as a senior advisor. So I want people to evaluate what I have to say in that context. Obviously, it is my view that, maybe not obviously, but I will certainly say it is my view that there's so much of a battering that these norms and these executive branch constraints can take. There's a real harm in having this continue. And for that matter, frankly, as we've seen over a period of time, intensify. So I think there's a significant amount at stake here. That's obviously also the premise of Susan and Ben's book that you mentioned earlier, that we have to have a discussion about what the presidency is, what sort of a president's, what we mean by this institution, what we expect from this institution, how we look at it. You said one thing I just want to very briefly comment on. We do have a tendency to, and I don't think this is actually a word, but I'll just use it anyway, regalize the presidency. A politician becomes president and immediately becomes a figure who can expect that his or her birthplace will become a historic landmark. People are interested in the names of their pets and in their hobbies and how they like to make their sandwiches. And everything gets elevated to a level which, by the way, is hardly healthy. And there are ways in which we also comment about, frankly, the environment of the White House isn't particularly healthy for the people who inhabit it. And that leads to some suggestions we make about reallocating the legal advisory function so that lawyers are not infected by that kind of an environment. And so I do, now it's also true that Americans can be very merciless in their judgments of presidents who fail them in some respect. So it works both ways, but nonetheless, I am struck by your comment, just because it is true that we have to come to terms with cultural attitudes toward the presidency and toward who's president, and the pomp, the circumstance, and many other aspects, trappings of the office, which frankly are quite unhealthy, especially if it turns out that somebody with, you know, and I'll use this term in the non-clinical sense, significantly uncontrolled narcissistic impulses manages to take control of the office. That is a toxic brew.
So can I answer that in a different way? And I agree with all of that. So as between me and Bob, and as between me and my lawfare colleagues, I've been for the last 4 years on the side of those. I'm not sure about me and Bob, but as for my colleagues on lawfare, the remarkable thing about Donald Trump's presidency, given how just extraordinarily destructive he tried to be about really all the institutions of government in our democracy, if you think about it, courts, the intelligence community, law enforcement, members of his own party, Congress, the press, individuals. He went after everything as hard as he could. The really remarkable thing is that we're still standing, and that these institutions, despite this pounding, they've actually operated, given what he's done, with all the problems that we've identified, remarkably well. It's actually a remarkable testament that we've made it this far with a president like this in office. And I'm confident that this is not at all meant to be a political statement. I'm confident that if Trump is gone next year, we have a chance to put things on a better footing. On the other hand, if he's president for 4 more years, all of his tendencies, all of them, are going to get extremely worse. He's going to get much better at putting the right people in office. He's going to have nothing to worry about in terms of future about re-election. He's learned over the course of his presidency about how to wield the office and where he can get away with things. And frankly, we'll have 4 more years with these problems continuing to be exacerbated and abused. And it's very hard for me to see. Again, I tend not to be an alarmist about these things, but if there's 4 more years of this, I'm not sure what the institutions will look like.
So that's a sobering assessment of what's at stake in this election. We have just a handful of minutes left, and one of my students posed a question quite a while ago that's a good question. I'm going to read it in abbreviated form as a final question to get your reactions. She asks, do you think the Democratic and Republican parties have different roles and responsibilities in how they shape the president's power going forward? Or is everything we're talking about at the end of the day really a bipartisan set of issues and a bipartisan matter?
I'll say something briefly and let Bob have the last word. That could mean a lot of things, that question. I'll just say one of the principles that we explained at the beginning of this book that guided us, we're not in the same party, we don't have the same political views, Bob and me. One of the things that guided us in this book was the golden rule, or a version of the golden rule, where we thought it was very important to abstract away from politics as much as possible in figuring out what the right reforms were, to imagine that any restriction that we proposed for a president we would be comfortable with for a president we supported, and any set of discretions we gave to a president we would be comfortable with if it was a president that we didn't vote for. So in some sense, these reforms are designed to be not partisan, and we tried to abstract away from that. Now, obviously, the chances of these reforms working is going to depend on when Trump leaves office. It's not going to happen when he's president. So it's going to depend on when he leaves office and what the control of Congress looks like. Most important thing is who's going to control the presidency. In that narrow sense, it very much matters, like in the next year, if Trump loses and if Biden is president and if the Democrats control Congress, and even if they don't, the burden of this is mostly going to fall on the Democratic Party in the short term. I mean, I'm not sure if that's the question, but that's what I think.
Yeah, and I'll end on an optimistic note, which is
please.
Okay. And I think we may have said this previously, but I'll just affirm it again. I think there are a variety of reasons why some of the Republican Party have followed Trump down a road that has been very, very problematic. I do think once Trump is gone, I think some of the forces that converge to create the Trump presidency will continue to be active, but I think there will be space for bipartisan agreement on some issues. And once you have bipartisan agreement on some issues, it's certainly a breakthrough on these kinds of issues, on these sorts of reform issues. And I don't think it's by any means out of the question. I'm not going to suggest, by the way, they'll march through and reform everything. There are other, huge issues on the national agenda that necessarily challenge the space that's available for reform, a pandemic and huge economic challenges, social challenges. But I think there's enough room for the beginning of a conversation and some action on a bipartisan basis within that conversation that could really make a big difference. But I also think if that opportunity is missed, I think it's a mistake to assume that if Trump is gone, he's gone forever, because somebody who thinks just like him could easily take his place.
A sobering but also optimistic assessment of where we are right now in this country. I could not be more grateful to the two of you for spending this hour with me and with us to talk about the book. I'm going to put it up again. This is After Trump, Reconstructing the Presidency, Jack Goldsmith and Bob Bauer. If we were together in person, which I so wish we were for the obvious reasons of being able to see you in person, but also because it would mean we weren't in the middle of a pandemic, I would now call on my students in our community to give you a rousing round of applause. I'm sure that they would. You'll just have to take my word for it that this has been just a fantastic event, and I'm so grateful. I know you're both very busy that you made the time to talk with us about this enormously important book. I hope those of you with us watching live and those who watch this recorded will pick up a copy. It's a really significant work, and I hope very much that it influences these conversations in the days ahead. So thank you so much again, and
Thank you
take
very
care.
much.
Thank
It's
you,
a
Amanda,
pleasure.
for your great questions. We really appreciate it.
Yes,
This was
very much.
great. Thank
Have a
you.
good evening.
Bye.
Thank you.
You too. Take care, everybody.
Bye-bye.